Welcome everyone to this webinar. I am Rafael Carmona from the ICDR. And first, let me thank you all very much for joining us today. And I want to remind you that you can join as an ICDR Y&I associate. If you look for us, ICDR Young and International, you will find our website, and there you will find registration forms in English and in Spanish, as well as recordings from all of our previous webinars. You can also join our LinkedIn group, again, ICDR Young and International. You will find us and you can request to join. We will be posting all of our updates there too. And I also want to thank all of our co-sponsors. First, Careers in Arbitration, an amazing tool if you're interested in arbitration. Amanda Lee regularly posts about open positions in arbitration and career advice. Also, the Rising Arbitrators Initiative, RAI, great network of young practitioners already with some experience that may be also looking for their first appointment. So if you fit that description, definitely check them out and try to join. And in particular, I want to thank from RAI, Joanne Lau and Victoria Keegan. And also REAL, which stands for Racial Equality for Arbitration Lawyers, which is a very self-descriptive goal and an amazing goal to try and pursue. So also definitely check them out. I will be your moderator for today. And if you have any questions throughout the webinar, please use the Q&A function, and we will try and address them at the end of the webinar. And with that, I want to introduce our panelists only very briefly, because we could talk about their experience and accomplishments for hours. So first, we have John Fellas. John is an independent arbitrator based in New York. He has been recognized as a leading practitioner by all the major legal directories. And just to give you an idea, I quote from one of them that describes him as one of the best. His reputation is phenomenal and deserved. We have also Crina Baltag. Crina is a professor at Stockholm University, where she is also co-director of the LLM in International Commercial Arbitration Law. You may also know her because she is the editor of the Kluwer Arbitration blog and co-managing editor of the ITA Arbitration Report. Last but not least, we have Kabir Duggal. Kabir is a senior international arbitration advisor at Arnold & Porter. Kabir has innumerable awards, so I will just pick two of the most recent ones. He was named 2020 Dispute Resolution Practitioner of the Year for the Americas, and also was named Counsel of the Year by the Indian National Bar Association. We were also going to have with us Shama Loya, but unfortunately, for reasons that are completely beyond her control, she will not be able to join us today. She sends her apologies. With that, let me give our panelists also the opportunity to introduce themselves also a little bit more, and perhaps provide us with some introductory remarks about their experience writing and publishing about arbitration throughout their careers. And again, some initial thoughts about the topic. And John, perhaps we can begin with you.
Yes, thank you, Rafa, and thank you for inviting me to speak today. Let me give you just some, preliminary thoughts about writing. If you're a practitioner and you're a young practitioner, there are two things you need to focus on to develop a career. They're not mutually exclusive, but you need to think about both. One is you need to impress people within your law firm, because in order you need to do that in order to make partner. And if you don't do that, you won't make partner. The second thing you need to do is you need to impress people outside of your law firm. And you need to do that because that is the way to develop a practice. It's the way to make a name for yourself and a reputation for yourself. And so you need to focus on both. I actually realized early on in my career the need to do the second. Everybody tries to do the first if they care about advancing. I realized very early on in my career the need to do the second. And as a junior associate, I wrote an article. The article, I just happened to be as a junior associate, and junior associates get the worst kind of work, right? I had to serve process, figure out how to serve process on a foreign sovereign. there's a whole procedure for this under New York, US federal law. Anyway, I figured it out and I thought, you know, I couldn't find anything on this. So I decided to write an article about it. I wrote an article, I submitted it to a journal called the New York Law Journal, and they just published it. And I thought, oh, well, this isn't that hard really. But, you know, one tip is write about what you know. The second thing I would say is very shortly, a few days after that article was published, I got a call from an organization called the Practicing Law Institute. And they said, you know, we're thinking of putting on a program on international litigation. Would you be interested in chairing it? So the other thing I will tell you, writing an article can lead to further opportunities because I've been now chairing that program for about 20 years. The third thing I would say is, you know, and this is always a tricky one for a junior associate. You go to a partner in your firm, and I'm no longer at a firm, so I don't mind saying this, and you say, I'm thinking of writing an article. You have to be very careful not to be hijacked, because what will happen, what is likely to happen, and what I see happen again and again and again is, great idea, let's publish it under my name, I'll put you in a footnote. Don't do that, don't do that. Do it yourself, and don't go and ask permission, because once you go and ask permission, there is a serious risk that you will be hijacked in that way. Let me stop.
Perfect. No, thank you very much for those introductory remarks, John. Crina, any initial thoughts?
Oh, that I was going to say that I remember reading John's publications in the New York Law Journal, and I still remember them. But I think I took seriously the process of writing and publishing quite late in my career, and that was during my PhD. When I went to PhD at Queen Mary University of London, it was after spending a good years in practice, writing a good fair amount of submissions, including in investment arbitrations, and those can be lengthy ones, writing 2 master theses. And when I got to the PhD, I realized this is difficult. If you really, really, really want to write something that exhausts and maybe in years is going to be there and still used, you really have to dive in, live in that publication, in that writing process. And the reality is that you can do that when you are dedicated to that process. And that happens when you study for an LLM, when you write your PhD, when maybe you take some time off from your day-to-day clients and focus on that process. Of course, not everybody would like to go for a PhD, so it's not something that I recommend. But what I would recommend is what I've learned from that, and that is, it is a serious endeavor. And if something has to be of good quality, which should be, then you need to be dedicated 100%.
Thank you very much, Krinan. Kabir, your thoughts?
Thank you very much. Let me just begin by saying I'm delighted to be here. It's a very hard act to go after John and Crina. So the pressure is on. I'm convincing myself you kept me last for reasons of beauty. That's the only consolation. But let me just echo what the 2 prior speakers have said, because I think it's really pivotal. So there's no originality here, but you're going to hear it again. Point number 1, write about what you are interested in. That'll often lead to a good product. Something that excites you and doesn't feel like a job is also going to make you happy, and being happy is something we should not take for granted. Point number 2, this follows what Crina just spoke about. Writing is a skill, and skills have to be developed. It is something that is going to get better over time. If you are the 0.111% of people who are natural writers, good for you. We move on statistical probability. The chances are You are a writer in the making, like every one of us. And so the skill has to be honed. I look at my own experience and think, like Crina, probably not exactly like Crina, but in that vein, I started relatively early, but with smaller pieces that eventually became bigger and bigger and bigger, and then became books, and then series of books. But you see the evolution. I see it in my own case about how you improve, how you know how to put arguments, how you know the art of presenting what you are saying persuasively. And it's not just to arbitrators, although that is a very important skill, but you want to write things that people read. So think of both these points, writing about things you are interested in. I will wait because magically I know what Rafa is going to ask us, so I'll give you some tips. The question that often arises, I don't know where to begin. There's some tips about in relation to that, but stay tuned. But second point, just realize you will get better at it. It is doable, it is possible. And I'll stop here with that.
Perfect. Thank you all very much. So let's go through the writing process. And one of the first things, if not the first thing that you will need, is to select a topic. And of course, we know that international arbitration, it's a little bit of a niche in itself, but there's still a lot of things that you can write about. So what are some of your suggestions as to how to select subject matter to write about? Crina, any views on that?
Well, Kabir wisely, I think, pointed out to the first one, which is you have to choose a topic that you really, really enjoy. The writing process, it is a process, and you have to be there. It's more pleasant if you decide to choose something that, for you personally, it's relevant. Now, when you choose a topic, it's not necessarily, and for arbitration, as you said, Rafa, it's not necessarily something that is new. And if I may put the hat of the editor of Global Arbitration blog, if, for example, Enka versus Chubb case comes out, you will definitely receive about 20 posts on this exact topic for publication on Global Arbitration blog. But it may be that 5 out of the 20 will be published. Why? Because the approach to that topic, it's different. And that can be, you approach it from a comparative perspective. You picked up one point that the Supreme Court has highlighted in the judgment. Maybe you think that for your jurisdiction, that exact test is not going to work. There are various ways of approaching the same topic. What I think it's also important to consider, and we're going to discuss about this probably later, is that sometimes the topic or the breadth of the topic is going to be determined by where you're planning to publish the piece. Because you cannot approach, for example, what was my PhD thesis, the Energy Charter Treaty, the notion of investor, in a blog post. You can do it. I did it. But that was a short summary with the 2 points of why it was important to read about that topic. But if you want to exhaust the topic, then you have to think, well, where I'm going to publish. And maybe that particular topic, the way you formulate it is not appropriate for that one. There are also different areas of arbitration that are in constant developments, and we do have new ones emerging. Now, I know that it's a race, and especially I see this with young practitioners. I see this at Global Arbitration blog. I see this in the classroom. There is a race to be the first. And sometimes you really cannot be the first, but you can be the one that sets the right record. And I always give this advice that maybe you want to go to the original source, for example, the judgment or the arbitral award. And one leading example is the ICC case of Judge Lagergen in what we know today, the seminal case on bribery and corruption. You might want to go to the original source And maybe what has been written on that topic is not the correct one, because you have different sources that are not going to the original one and just taking secondary sources, using them without checking. And maybe it is your opportunity to set the record straight. Maybe that the view expressed by one author, it's not the correct one. So it's not necessary to be the first one. It might be the second one, but you might be the second one that is going to be cited and it's going to be the leading authority in that field. And I have to say that sometimes it's better to take chances. It may be the situation where somebody will tell you, but there's no case about that. Why do you want to write about that? I had the same situation when I wrote my PhD. There were 4 cases, UCOS was coming out, and that's it. And look where we're today with the Energy Charter Treaty. But sometimes it's good to take chances. Maybe you don't have cases to add to your theory, but maybe you can extrapolate. Maybe you can conduct a survey. There are different approaches to topics that maybe initially you think, well, it's not worth because nobody's addressing this. So try to be creative in the way you approach it. Try to think of different ways of discussing an issue. Try to take a holistic approach. Think about where you want to publish it. And I think most importantly, when you do, because John was mentioning, don't go and tell the partner, but if you're a student, if you have a mentor, if you're in a young mentoring program, try to seek advice and see, because more experienced people can steer you in the right direction, can give you different tips. They can point you to cases that maybe you're not familiar with.
No, thank you very much for that great answer, Crina. And unless there's any other comments from the panel, my next question would be like, okay, we've determined the topic and then we want to research about it. And one thing that I've noticed in international arbitration is that you can go, there are 2 extremes in your possible approach to research, and probably some in-between approaches. That you can go with the very domestic route, in which you just explore the domestic law of a particular country for this specific arbitration issue. But you can also go the opposite route of, well, let's just look for a very international or even transnational approach, perhaps take some comparative analysis in. And so I guess my question is, how international then should your research on international arbitration be? Kabir, what do you think about this?
Great question, Rafa, and I'm going to start off by sounding like a broken record, but I think it's worth emphasizing. Write what you are interested in, write what you know about, especially in the early stages of your career. I love that example John gave us. You know, he wrote about something he had researched, and that led to 20 years. And that's the first time I actually met John at the PLI training. So when you are beginning, pick areas you are interested in, pick areas what you know about, and try to make a note out of it. Now, let me just provide some suggestions when you have the writer's block or you have the problem selecting a topic. I'm going to steal a little bit of what Crina said again, because Crina, you're used to that now, me stealing your ideas. You may have come across an interesting idea when you were in law school. Think of making that into a post. Another way you can come up with a topic, little bit of care and caution here. You have discovered something interesting you are working on. Now, the slight caution that I suggest here is, don't write about something that is directly going to be an argument you are going to present tomorrow. Firms will assassinate you faster than you say assassinate if they see you previewing arguments or you doing something that is directly going to implicate case. But when you research something interesting that is broad, that has not been touched upon, that's always a great idea to publish. Another area, especially when you're beginning, case comments and timely developments. Very interesting areas to focus on. Crina provided a lot of great examples there. Think of a unique angle. Institutions are innovating, right? The ICDR has come up with so many cool ideas. Pick up on one of them and try to give it a unique dimension. You are better off in your early stages writing shorter pieces, right? Blog pieces. This was not to suggest that blog pieces are easy. In fact, because they are small, they're sometimes harder, right? The standard thing you're told, right? If I had more time, my essay would be shorter. But they are good places for you to begin putting ideas out there in the universe. Just to circle back where we began, write about what you are interested in, what you know about, what you have an inkling about, what excites you. As your career develops and you have an expertise, quote unquote, if you want to have an expertise, in arbitration, we are often told your expertise is arbitration. You don't want to have a subject matter expertise to box yourself, but the opinions are divided there. But if you have an expertise, you can then hone in on the expertise. But initially, build the skill, and build the skill by writing about what you're interested in, what you know about. Gonna stop here.
Perfect. No, and thank you very much, Kabir, for that very interesting answer. And we've talked already about this that I'm going to mention, but there's clearly very different type of publications, right? From more of a whole book or perhaps a shorter law review article that still needs to be very well researched, to the option of shorter pieces like blog posts. And I wanted to invite to see if John, you had any thoughts also on how to decide whether you should go for a shorter piece or a longer piece. Like Kabir already provided some ideas, but perhaps you can add something else.
Yeah, I think you need to think about how you want to present yourself, and how you want to present yourself will in turn be determined by your career goals. If you're a young lawyer now, you want to be an academic, you should write a very different piece if that's what you want to do than if you want to be a practitioner, if you want to be an arbitrator. You have to think about that. An academic piece tends to be much longer, it tends to be more scholarly, it tends to have more footnotes, it tends to be more normative than descriptive, it tends to be published in a different place than a practitioner's article. And one academic piece can absolutely make your reputation. I went to law school with a fellow who, about a couple of years out of law school, published an article called "The Right of Privacy" in the Harvard Law Review. He got a call within about a week from Yale, and he's now a professor at Yale, just on the back of one very, very good, often cited now, academic piece. The professor is Jed Rubenfeld. But it's different if you want to be a practitioner, right? Writing one piece as a practitioner really doesn't help you, because you want to be in practice. And if you want to be in practice, what matters is that you remind people you exist. People need to remember you exist. And publications are a way of reminding them you exist. And so a series of shorter pieces is a much better approach. And frankly, writing something that's deeply normative, if you want to be known as an advocate, it really doesn't help you. It's, people who are going to hire you, their eyes are going to glaze over. They want to have a practical approach, a practical account of the law. And it's different again. If you decide, listen, I'm really interested in oil and gas arbitration. This is what I want to be known for. So you need to write about that then. That's what you should focus on. And it's different again if you think, I want to be an arbitrator, because then you kind of want to try to write from that standpoint. However, it's important that there's some congruity between who you are and what you write. You know, if you're 1 year out of law school and you decide, I'm going to write about what it's like to be an arbitrator when you've never sat as an arbitrator and you've never been in the hearing room, what you write is going to be nonsense. And people will just think it's odd. So look, I think what you need to do is take stock of where you are in your career. You know, frankly, as a young practitioner, just write anything that you think is going to be easy to write. Write, as Kabir said, write what you know, because that's the easiest thing to write about. You've suddenly, you know, been asked to research something and you think, oh, there's nothing in writing about this. Let me write about that. But as your career develops, you may decide, listen, I want to focus on oil and gas arbitration. So I'm going to write about that. Or I want to be an arbitrator now. So you've sat in a few arbitration hearings. You have some thoughts about it. Write about that, you know, how an arbitrator could make proceedings more efficient. What should she do? Right from that standpoint. And finally, and perhaps, you know, this is the most important thing, write when you have something to say. You know, a lot of stuff that I've written, I wrote a piece relatively recently, it's probably a few years ago now, on cross-examination in arbitration hearings. I wrote it from the standpoint, you know, of being an advocate, but also being an arbitrator and observing cross-examination and seeing what goes wrong and thinking to myself, you know, if that person had done this, it would have been better. If that person hadn't done that, it would have been better. And so write about what you know. That's almost, write about when you have something to say. That's perhaps the most important piece of advice here. Thank you.
Thank you very much, John. And I wanted to ask a little bit the same question to Crina, but also with a follow-up of how do you choose specifically which publisher you should try and have for your piece? And Crina, I'm very sure that you'll have some thoughts on that.
Well, absolutely. I just wanted to add to John's brilliant answer. If I may add, because it's complete. One thing that you also have to think about, and this is where the publisher also is relevant, the choice for a journal or for a blog post and so on, is how fast do you want that to be published? Because if you want to, obviously, you want to publish in a Harvard Law journal, and you want to put that, and everybody appreciate and cite that. But the problem is that most of the journals have a peer review process that takes a long time. So if you want to publish, for example, going back to Enka versus Chug on applicable law to the arbitration agreement, and you want to publish now, you have to think twice. It will take 1 year, if you're lucky, for that article to be published in a journal, because most of the journals, they already have the issues, for example, for 2022 already booked, or most of them already in production. And perhaps a blog post, which will be published in, let's say, 3 weeks or 1 week, will be what you need. Now, don't confuse the fact that a blog post is something that you go, unless it's your blog, obviously, but I'm referring here to Club Arbitration blog, for example. It is also a peer-reviewed publication. So you're going to benefit from the tremendous help of the peer reviewers, because I think that's help that you get to improve your piece. Of course, not the blog, not in the same way, maybe detailed as a journal one, but still is a process, and you'll benefit from this feedback. So I think the question, to add to what John was saying, is to think about how fast you want to publish. Now, when it comes to the publisher, we live in a century where everything has to be online. You need to have access to here on your phone. All the publications have to be accessible. And there are two issues in addition to being online that everybody can access, is if the publication is behind a paywall or not. So Club Arbitration blog is a free resource. Anybody can have access to that. You don't have to pay a fee. But of course, when you come to Cambridge University Press publications, Oxford University Press, Club Arbitration, Brill, Edward Elgar, Springer, and I think I'm naming Sweet and Maxwell doesn't have online presence, but if you come to the major publishers that are relevant in the field, and I'll come to that in a second, it may be that everything is behind a paywall, meaning that the audience that you're targeting, it's slightly different. So that's something that you have to take into consideration. When it comes to, let's say, choosing the publisher, I think that's more relevant when you have a book in the sense, because a journal is a journal. And now there is quite a lot of pressure, at least in Europe, to have available content online that is not behind a paywall, and there are funds for that, and that's something wonderful that happens. So when you publish a book, for example, that's also important, because the question that you have to ask yourself, do I want to be with a publisher that is specialized in arbitration, or do I want to be with a publisher that is more international? Do I want to be with a publisher that has, as I said, an online presence, and so on? So these are elements that you have to consider. Nowadays, also, this is a bit of a grayish area, because, for example, Kluwer Arbitration hosts journals and books of Oxford University Press. There is an agreement. So it doesn't really matter if a publisher with Oxford, you're going to be on Kluwer Arbitration database as well. But I think what is important is to, as John and Kabir were saying, look at yourself. What's the audience? What's your purpose? Why do you want to publish? How visible do you want to be? Maybe reputation-wise. Although I wanted to pause on this, because the question was on also on long pieces, short pieces. Kluwer Arbitration blog posts are referenced in arbitral awards. And are referenced in applications to the, for example, US Supreme Court. So the fact that it's a blog post doesn't mean that it doesn't have the quality, sufficient quality to be cited in important pieces that are present in our work. I will stop here because we have more opportunities to detail this.
Thank you, Crina. And I think you mentioned, and John also talked a little bit about your target audience, right? And I wanted to get a little bit more of your thoughts, either Crina or John, whoever wants to take it, on how much should that impact not just the publisher, the Crina you mentioned that may have an impact, but also perhaps your style, right? Depending on whether you want it to be aimed for in-house lawyers or academics, or arbitration practitioner, arbitrators. John, do you have any comments first, perhaps?
Yeah, I think it's pretty decisive. Your style will certainly be influenced by who your audience is. I said this earlier, but if you want to be an academic and you're writing for an academic audience, you will by its nature write something that's far more normative, that will focus more on what the law ought to be, would be more critical. Than if you're writing for an in-house lawyer anonymous in-house lawyer who you hope may hire you one day. An in-house lawyer is really, at least professionally, unlikely to be interested in the normative account of the law, because it's not going to help them. That you think the law ought to be this or that in a particular area isn't going to help them win their case. What's going to help them win their case is showing you are knowledgeable about an area of law, and showing you've got some good ideas from a practical standpoint, from the standpoint perhaps of how to present an effective case in an oil and gas arbitration or in a pharmaceutical arbitration. I think, if talking to young practitioners, you don't have a lot of time. You can't sit down and write a 3-volume treatise on arbitration a la Gary Bourne. You have time really to write a relatively short piece. What I found, early in my career, was an easy thing to write about was a recent case. Case comes down, you see it, you know enough about the law to know how it fits into the law as a whole. And you can just write about it. And, it's 2,000 words, and generally shorter pieces can come out more quickly. But yes, if you're an academic, be normative. If you're a practitioner, be practical. And if you want to be an arbitrator, try to write about the standpoint of the arbitrator.
I was just going to add one thing is from Kluwer Arbitration blog perspective, because personally I have to be critical in every publication that I have, but with caution, because as I sit as an arbitrator, I want to make sure that that's properly neutral. But for Kluwer Arbitration blog, we have case comments, and that's something that John has mentioned. You need to be critical as well when you look at the case. So you have the descriptive part, but necessarily you need to have your point of view about whatever you choose to discuss from that case. And I think this is something that you need to exercise. It takes quite some time to develop this skill. And this is why, as Kabir was saying, is important to practice. Always ask the question, why? I think this is what is important, why I always tell my students, don't just take everything for granted, just ask yourself why, and what is the consequence of that particular issue in the entire scheme of, for example, the arbitration process, or broadly of affecting the parties, affecting stakeholders, and so on and so forth.
Thank you very much, both of you. And now let me address a little bit the elephant in the room, although we've talked about it a little bit, which is that, of course, we all want to devote hours and hours to writing and researching a beautiful piece, but a lot of the times you're going to be very busy with your workload as the law firm or any other professional commitments that you have. So I wanted to see if you can develop a little bit more some suggestions on how to combine those two things. And Kabir, perhaps you can provide your views on that.
Sure. This is the elephant in the room. And I'm going to start off with what John mentioned. Don't get fired. You may want to write a 50-page, the best article. You want to cover every authority and make it the best piece ever. Writing involves time. And when time is not at your disposal, you want to make the most of it strategically. Now, we begin off where we started with, right? What you know about and what you're interested in. We cannot emphasize this enough, because then if you have to stay late, if you have to stay on a Sunday, you don't hate yourself. So we start off there. It is a good idea early in your career to work with a co-author. Now, couple of reasons. You can bounce ideas off each other. That's a great thing. But it also creates some amount of accountability. Now, I'm again going to pick off from what John mentioned. Select your co-author sensibly. It helps sometimes to have somebody senior guide you. When you write something, if you're the junior, let's just agree on the rules of life. You're going to write it, somebody's going to edit it and give it back to you, and their name is going to go before yours. Let's not question how the world works. But if you have the right person and the document comes back to you bleeding red, the first 24 hours you will be in the fetal position crying. But after that, hopefully you learn what is being advised. This is the point that writing is a skill that has to be developed. It doesn't need to be somebody from your firm, although if you have the right mentor, do it with somebody in your firm. Take John's point, not somebody who's going to steal your work, which is prevalent, but somebody who's collaborative. But it can also be people you admire. Crina spoke about mentors, right? virtually all the young organizations have mentorship schemes. Find a mentor. It also can be peers. We always think of networking vertically. We forget that often it's your peers. Hey, I'm working on this. I'm working on this. We like each other. Let's do something fun. It can also be a test of your friendship. Do you like each other at the end of it? But be strategic, be smart, try to make it a learning experience and do it in a manner that helps you accomplish what you want. And this may vary based on who you are and what you want from your life. I'll stop here, but be sensible.
Thank you very much, Kabir. And I want to sort of move on to what will be the next section, in the sense of like, okay, let's assume that we've already had our piece or whatever it may be published, which is already an achievement in itself. But of course, you want to make sure that this is a very well-known and used piece. What are some steps that you can take, perhaps, to help promote your piece, or let people know that you've written this very interesting article or book chapter or blog post? And Kabir, can I ask you again on your thoughts on this?
Definitely. I begin with what John had mentioned. It depends what you want to do with the article. Practitioners, this is so true. Ever heard that phrase, there's no dearth of lawyers? Right? We want to keep showing that there is value and we're there and we want to get our name out there. And if that is your goal, put it on social media, reach out to organizations that you are affiliated with to put it on social media. People have mixed feelings about LinkedIn. Should I be putting my own stuff? But this is where having friends is helpful. They can put it for you. Organizations you're affiliated can put it on. You can also send it to clients or to people who might be interested in that topic. Now, this, if you've written something interesting about the ICDR, you should be sending it to Rafa. He may be interested. It can be something that the institution may want to showcase. So, if you're writing about a topic, a key development, send it to clients that might be interested. If you're doing more academic pieces, share it to other academics in that space who may want to engage with that article. But it is important that you do put it out in the universe, either directly or more elegantly with friends, because you do want to have engagement. Writing for the sake of writing isn't helpful. You want people to read it, you want people to benefit and engage, hopefully engage positively. But to follow the Hollywood quote, right, any publicity is good publicity. So as long as it's getting views, you're probably doing something right. But I'll stop here.
Perfect. No, thank you very much, Kabir. And my next question, again, you've been published, you've been trying to promote it. And then sometimes it happened to me that I've done all this, and then I say, like, will this be really a useful article? Because it's really hard to measure. Again, publishing in itself is a success, right? But how much impact does that publication have at the end of the day, or even at the end of the year or a couple of years, right? And I wanted to ask Crina, how can you measure that? You have probably citations for academic articles or publications, but perhaps there are other ways to measure it.
I always take a look at the Google citation, scholar citation, to see how the papers are doing. but I think what is important is to get, as Kabir was saying, when you're sharing your publications with your colleagues, with those interested, you might want to get the feedback. I think more than having the numbers, how many citations do I have for that particular paper, perhaps I would be more interested in learning if that paper was useful for a particular case. I'll give you an example. I wrote on the denial of benefits clause, I think it was 2007 or 8. with Professor Lucas Mistelis, and we updated the publication for the Max Planck Encyclopedia on Public International Law in 2019, I think, or 20. If I look at the citations on Google Scholar citation, this is a very small number. But when I look at the arbitral awards, for example, that's something that is worth considering. Exactly on this example of the denial of benefits, one recent award before the SEC that came out, which has paragraphs from the publication. But besides this, I think it's important, and I go back to go to your colleagues to learn how useful that publication was for their work in preparing the briefs, in thinking about the strategy of the case, maybe in considering points that the other party is likely to raise. And in terms of citation is something that you don't have, again, you don't have to get desperate that another article is not putting your name there, because not everybody has access to the same databases. Not everybody, for example, if you decided to publish with an Oxford journal, not everybody has access to those journals. And it's not because your publication was not of good quality. It's simply that was not accessible to whoever is writing a subsequent publication. And the last point is that submissions by the parties in the arbitration, if you look at investment arbitration, you say, okay, the awards are public, but the submissions are not, or maybe they're not public. And it may be that your publication sits comfortably at the center of an argument one of the parties is making. So although you're not aware of that, it's a very useful publication you have. Again, what I mentioned in the beginning is a solid publication will resist the test of time. It will be not necessarily the first one, but it will be that one that had the highest quality, and even in 10, 20 years will be there as a reference. So if something doesn't come up now, maybe in 2 years, keep an eye on that. If you had a great publication, it will have the test of time.
Perfect. Thank you very much, Crina. And we have a number of questions, so I want to move on. Perhaps you can talk a little bit more about what do you think are the main benefits for young practitioners publishing about arbitration. And we've talked a little bit about it already, right? In terms of John's experience about publishing and opportunities that followed. But perhaps, Crina, you can give also some thoughts on this point.
I think we all mentioned the benefits. Obviously, is visibility. I think it's the first one. But let me tell you some of the something that is not that selfish. That is like me. I have visibility and so on. So we have really wonderful stories from Club Arbitration blog. We have examples like John's example, when somebody has published on a particular topic once, twice, and this was many years ago, and now she's a specialist in that particular issue. She's invited to speak in conferences and so on. So these are beautiful stories, I said, but this is the person. But we had a situation when the publications of different scholars, different practitioners had an impact on the development of the arbitration law in that specific jurisdiction. So sometimes we do something, either we know that it might help, or involuntarily that will build, will create, will promote arbitration, dispute resolution in our jurisdictions. And we had a concrete example with some situation with the recognition and enforcement of foreign arbitral awards in Pakistan, with some sort of an internal regulation of the courts, which was amended after a series of articles published on Club Arbitration blog. So it's not only your visibility, it's not what you achieve, what you bring to yourself, you enhance your CV, maybe you get a promotion, you're called to speak in conferences and so on. But think beyond this. Think what do you return? What do you pay back? Let's put it this way. And I think we have to be a bit more conscious of the fact that our actions, our writings may have a meaningful impact. And of course, a less meaningful impact. So we have to pay attention to that as well.
Perfect. Thank you, Crina, because actually that segues very well into what was going to be my next question that is also related to one of the questions from the audience. We have one question is, do you think that publishing may adversely affect your chances of being hired by a law firm? And I also wanted to ask generally, what are some of the risks that can be involved when you're publishing something? John, perhaps you can provide some insight.
Yeah, it's a great question. I don't have a great answer because I don't know. You know, I publish a lot, and I actually, you know, there's a lot of people in the arbitration field who, and I've heard them say this, they do not take positions. When they publish, they will write something quite bland, quite descriptive, and don't take a position. And they do it for particular issues. They fear that they may not get hired. They fear that they may not get appointed as an arbitrator because they've taken a position. I don't follow that school of thought. I've always taken a position on issues. I always, I've been critical of cases, have a particular view on certain areas of law that I have no trouble putting in writing. It is possible that, I haven't been hired or haven't been appointed because of that. I just don't know. I've never ever had anybody say to me, well, we were going to appoint you, but then we read this article and we decided not to. I've never had that happen to me. Or we were going to hire you, but then we read this ridiculous position you took in this article, so we didn't. I've never seen that happen. So, I don't know what advice to give there. Obviously, if you take some absurd view, extreme view, that may hurt you down the road, but I don't think you should be concerned too much about expressing a view. Obviously, if you're in a law firm, you need to be a little careful in the sense of you don't want to express a strong view when you're on an issue where your law firm may be on the other side of that issue. That could get you into trouble. But other than that, just say what you feel, say what you think. I think we're all better for it.
Perfect. Thank you very much, John. And let me take also some questions from the audience. One of the first one that we received, I think it's an interesting one. What would be your publishing advice for pre-law students that are aspiring to pursue arbitration later in their career?
My advice is there's time. You don't have to be doing anything now. And frankly, I don't think you should. You probably don't know enough to write anything sensible in all candor. And with the greatest of respect to the person who answered the question, wait until you know something and then write it. I don't think it's going to help you down the road. Yes, there's plenty of time for you to write something.
I was just thinking of the students who have to write their dissertation at the end of their LLB studies, and some of them can use that to, as John said, just that's enough work to be done at that stage. But that would be a wonderful, solid foundation for something you're going to do in the future. For example, if you're going to write on something insolvency law issue for your LLB dissertation, think about maybe in the future you're going to look at arbitration and insolvency, and that was the solid foundation of understanding this whole concept. So I truly agree, just use this, it's a learning experience, learn as much as you can, enjoy it, and then there will be enough time.
I mean, the other thing, let me just add here, you need, doing a long thesis like an LLM thesis, it teaches you how to write. And how to sustain an argument. And so focus on learning on that, the argumentative process and learning how to write. There'll be plenty of time to put that into practice over the course of your career.
Perfect, thank you. And Crina, as usual, you've been a little bit precise in mentioning the LLM thesis, because there's a question about someone who is writing now their LLM thesis, but they mentioned that what would be the speaker's advice in terms of topics, especially for authors looking to work majorly as counsel, because the thesis may be more inherently academic. So how can you achieve that balance?
I hope it's not one of my students, but I'll just my own experience when I wrote my LLM thesis. I was working on one of the exit cases at the time was Mikola against Romania, and I was fascinated by all the jurisdictional issues raised. And I had no time, we had no time to explore that in detail during the master program. I thought that's a great topic. My professor, Patricia Shaughnessy, said, well, I'm not an expert in investment arbitration, but I know somebody who's an expert in that particular topic, and that was Noah Rubins. So I greatly benefited from choosing something that I really liked. I had no theoretical, maybe just the basis of understanding the topic, but I had the fortune to benefit from the advice, from the supervision, from reading early drafts of somebody who practiced a lot in that field, and that helped tremendously. So while students say, well, this is an academic topic, this is purely theoretical, try to reach out to maybe your professor and see if she knows somebody that is in the field. Kabir, who wrote a lot about sustainable development, John, who wrote about finances in international arbitration, costs, and so on. They know about it. Get that perspective, and maybe you are not going to use that in your thesis, but that will help you understand the topic, the issues, and later you can publish that with this additional input from this wonderful experts. And that will build a relationship with Kabir and with John. And that will give, as I said, a solid basis, a solid quality for your LLM thesis. So I cannot say which topic to choose, because we go back to square one. But I think you can make use of any topic if you add this collaborative aspect to it.
Perfect, thank you. And I don't think we'll have time for all the questions, but let me pick one or two more. Velislav is asking, according to your opinion, what can be a good strategy when trying to pick a good angle of a certain topic in order to bring novelty to the discussion?
If we have the magic answer to that very great question, writing would be a lot easier. That is really the million-dollar question. So, you may wish to do a couple of things. Think about how you can situate a development within a broader context, right? Raise the stakes. So we are seeing emergency arbitration as a development, but put it in a broader context of the future of arbitration or responses from arbitration. You can make it comparative, right? Look at what the ICDR is doing in relation to other institutions or in relation to what courts are doing, right? So put a comparative perspective, put a regional perspective on it. You're having decisions. Now, on regional points, they're very significant. Writing about a key development in country X may be super interesting for country X. If you want to publish it in an international place, make sure you are, by definition, providing an international dimension, why that is significant for everybody to know about it. But try to think about things critically. If you're looking at a case that has a dissent, that's almost always an awesome way, what is the majority saying? What is the dissent saying? How do we contrast them? If a case is disagreeing with prior precedents, right? Using the word precedents very loosely here. Compare and contrast that. Those could be some ways to try and make your contribution become a little more unique, a little more interesting. Just one final point, John. Sorry, it seemed like you wanted to speak.
Whenever you're done, Kabir.
Sorry, just one last point. I just think this is important. We sometimes think and we put pressure on ourselves that our unique dimension has to be so unique that it is going to change arbitration. It's going to break arbitration forever. And there is no such expectation except from you. What you need to do is valuable contributions that may be ignored. It doesn't have to be earth-shattering in the way one may expect it to be. Just wanted to put that out there, and I stopped.
And you know, I have two comments actually, but one of them was going to be to echo what Kabir said. Don't overpressure yourself. No one is going to be the next Flaubert. You don't have to put that kind of pressure on yourself and think I need to have some original idea that no one's ever thought of. You know, don't aspire to that. I mean, you might do that, and if you do that, that's great. But that shouldn't be the standard by which you measure your publication. Very few people can do that. The second point is think outside of the box, right? You know, and give you an example of that. If you have a case in the courts of your country that involves involving arbitration, that involves, say, a Brazilian party or a Chinese party, that is going to be of interest to folks in Brazil and folks in China. And there are going to be arbitration publications in those countries that actually will more likely than not be interested. You know, here is what happened in the courts of my country in a case involving a Chinese party or a Brazilian party. And so do some research because you will probably find a receptive audience for that. Now, of course, you know, you're making a name for yourself in another jurisdiction to the one you practice, but you know what? It never hurts.
Perfect. Thank you very much. And again, we have a bunch of other questions, but let me just pick one final one. Yulia is asking, how do you ensure that your publication remains neutral and you're not providing too much support in favor of only one view? Or in other words, is it difficult to strike a balance between taking a critical viewpoint and not having the publication be used against you at some point?
If no one wants, I'm happy to take a first stab. There's nothing inherently wrong with taking a position if you think the position is right and if you can live with the consequences. I just did want to put that out there. Law firms tend to be risk averse and don't want positions very often taken. But, you know, if you think you have the right position, I give Professor Gaillard as an example, or Gary Bourne as an example. They've written a lot. I'm sure those are used against them, but they believe in what they've said. And there's nothing wrong with that. Articles that are purely descriptive generally tend to be less useful unless they are in the nature of a press release or a client alert. I just also do acknowledge that reality. Even Kluwer Arbitration blog will not accept a position that doesn't have it, that's purely descriptive. They're just not going to do that. That is, you know, that is not of great value. But think long and hard about what you are comfortable saying and how far you are ready to go. A very standard line lawyers will do is they'll articulate an issue, they'll present different points of views, and it often ends with remains to be seen how tribunals will decide that matter. Now, that may be one way to approach it, but wanted to give you just some of these ideas that taking positions, you know, if you're very scared and very concerned, talk to your firm about what may be appropriate or not. Some firms have publication committees that will review what you write. If your firm is one of those, then you probably want to be safe. So, I mean, I don't know if there's one answer to give, but like anything in life, use common sense, have an awareness about what you are comfortable with, what risk you're ready to take, and just go for it. I'll stop here.
John, did you want to add anything else?
No, Kabir said it all.
Okay, perfect. So I want to then close the webinar, but I want to give the panelists an opportunity to also provide some closing remarks or anything else that you may think that we have not discussed, although I think we've covered a lot of topics. So John, perhaps beginning with you.
Sure. Yeah. Some years ago, I read an interview with the English novelist Martin Amis, and he said something like this. He said, after I published my first novel, I expected people would recognize me on the subway. I expected people would recognize me on the street, and it didn't happen. And, you'll write something and it'll be published and you'll think to yourself, now people are going to write to me and now people are going to view me as an expert in the field. It doesn't happen. It doesn't happen. No, you don't write an article and some client calls you up and says, I now want to hire you. It just doesn't work like that. It's a long game. And so don't think one article, unless it's some seminal academic piece, is going to be game-changing. As a practitioner, you really have to sort of take a long view of this. And I can say this, I've had a longish career, but you need to actually write regularly to develop any kind of reputation. One article is not going to give you a reputation. And you need to get it out there. You can publish in some journal or other, and maybe some people will read it and maybe some people won't, but it's important to get it out there. I actually generally, when I publish something, I get a reprint and I just email it out to all my contacts. I don't know what people think about having their email boxes, filled with my articles. But, I have people often tell me, oh, yeah, I emailed this. It was very interesting. I emailed this throughout my department in my in-house team. Or I've had people say, I emailed this throughout my the arbitration group in my law firm. If you have something to say and it's of interest, especially if it's practical, if that's what you aspire to be, the word will get out. But you have to take the initiative on that. And Kabir spoke about being elegant and having your friends do it. Just do it yourself. Honestly, that's my view. But then I'm shameless, unlike Kabir.
Sorry, I was muted. Thank you very much, John. And Crina, any closing remarks?
No, absolutely. I think what is important to remember is that you don't have to force it, although as John says, you have to do it. You have to focus on the quality. And I think everybody's concerned about visibility. And you have to think that visibility is the result of you publishing, as John said, constantly. So that's not perhaps the scope. The scope is to make sure that you produce something of good quality that will be used in a meaningful way. But I wanted to say something that perhaps we did not mention. I mentioned the peer review. You will get rejected probably many times. And we rejected Global Arbitration Blog. My publications, and I look at Kabir and John, they cannot say, no, that's not true. We all got rejections at some point. And this happens to young ones, happens to more experienced one, happens to maybe Gary Bourne, I don't know. But you have to think about this as an opportunity to take that rejection and see what you can improve. And usually you get some feedback. And I think that feedback is very important. Take that and work. And as Kabir was saying, it's an exercise. You have to improve that. If you don't get the feedback, then go and ask for the feedback. Why is this not publishable? What should I do better? And that's one aspect that you have to keep in mind, like anything in life. If you get a no, go back and build a yes. Work hard, address the issues, go back, resubmit, and you'll get the yes. Thank you.
Thank you, Crina. And Kabir, any final comments?
Again, I'm going last, and I'm going to stick with the beauty bit. Just one point. Everybody who has come here is likely somebody who has an interest in writing. This is, by definition, why you have shown up here, unless you are totally keen to see the beautiful me. Now, putting that aside, you have come here because you are interested in writing. And go for it. Don't artificially put a barrier. This is something I cannot do. This is something out of my reach. I really would encourage everyone here, give it a stab. Take the great advice you have heard from Jean and Crina. A rejection is not the end of the world. You will likely come out stronger. Somebody will eventually publish your article. It's a good thing. It's a way to make you stand out in a crowded profession. It's a way for you to develop your writing. It's a way for you to develop your thinking, right? You often are delving deep into a topic or thinking deep about a topic. All these are wonderful things. Our practice becomes better when we have scholarship, when we have deep thoughts. So really go forward, embrace it. There are 95 people who have stayed till the end. Connect with each other, become friends, try to collaborate. It's fun to be bouncing ideas off. Do it. The only way to become good at it is to do it. So do it. And with that, I stop.
Thank you very much, Kabir. And again, thank you all to all the panelists for their great insight. Thank you again to all the co-sponsors and of course to all of you who connected with us today. It's been a pleasure. And with that, I think we can conclude the webinar. Thank you all very much. Take care. Bye, everyone.
You.
Thank you. Thank you.